Yesterday, closed down. And I want to mention one. If it is not signed by the then I will be mentioning it, and I have already informed the other side also. And
For what?
Signed the option, then I will have to file an application for one of these.
No, not upload one.
Only option to the extent that the option is permitted and reference the one that if the applicant goes against me, then the order of the executor and the this thing can be imposed again. If permitted under the law, that is there. Otherwise, you should will take advantage of the order is in account models if permitted under the law.
No, I will see.
Yes, that can be the big deal. I don't think they take advantage.
I will
of sort of
No, that I have corrected that. I have done that also.
Yeah. Okay.
For what?
Or mentioning listed.
At the end of the circuit, why you are mentioning? What is the urgency? What is the urgency? And what is the matter about?
Senior secretary.
Correct. Senior secretary, you have mentioned the matter. What is the urgency? Urgency has to see, then I can allow the matter. Because these are only the 4 days is left. What is the urgency? Who is your senior? What is the urgency? Give that. What is the number? Other matters. Tell me the urgency, then I will see. Go read. Come. Yes.
For the appellant may not say.
Appellant, complainant, accused. Appellant, complainant. Accused is just acquitted
Acquitted.
under 138.
Once acted on.
Yes. What ground he has been acquitted?
On the ground that I have not produced the sale agreement dated 5/12/2016. That which was executed between this complainant and the accused person.
Correct.
That is the
5/12/2016.
5/12/2016.
Correct. Correct. Then.
May I start with the Here, the fact of the case is like this. On 3/5/2016, a sale agreement was executed between this complainant and another person who was the recorded tenant of survey number 362/2
Correct.
Area is 1.5350 hectares, situated in Vitakari village under Pradhan sites. And that sale agreement was done. And the total sale consideration amount is fixed as 1,70 lakhs rupees. The agreement was executed between this complainant and one child. Thereafter, what happened, my lordship, at the time of execution of this sale agreement, dated 3/5/2016, an amount of rupees 5 lakhs has been paid. The child. Thereafter, some detail has been given how to make the future payment, my lordship. That was. Meantime, what happened, my lordship? One Arun Kumar Agarwal, he approached his complainant and thereby he expressed his desire to purchase some 40. Now, thereafter, this accused person approached one approach.
Just a minute. Mr. Tabir, you have not challenged the other findings which the London court has gone in favor of the accused. Only one finding with regard to the agreement. Correct. Agreement was not produced. That's why he has not proved the case and he has been acquitted. Kindly come to the question number 12 of the 330. Yes.
So it has been admitted and 330 CRPC that there was a agreement. As per the circular, the working meeting better than legal.
I don't know one how to teach.
330 is not a full evidence at all. It's full evidence.
But once it is admitted, can it be proved?
Yes, sir. Even though I will satisfy to that. Recently, the Honorable High Court ordered on the basis of passed an order
getting that 330 in 130. Until unless the mandate provision of 138 has to be proved by the complainant. The complainant has to stand in his own land. In the admission of 330, that cannot be taken into account for proving the legal record. Now, in this case, you will see the notice was issued by the complainant hearing under 138. In that, it has mentioned that agreement, alleged agreement between me and the complainant. Now, it is the duty of the complainant to produce entire document. It is legally mandatory. Yes, failed to do. So the weakness of the defense cannot be taken into account. We are producing the in that in this commitment has taken into account that in 330 the actually the admitted about the legal look, but the government said there also the admission cannot be taken into account because the service of the legal notice has to be proved by the complainant
Yes.
as per the legal mandate.
Yes.
So your lordship, my continuation is that I have taken in the cross examination.
Yes.
Your lordship seek the cross examination of the complainant.
Which paragraph you are relying upon of this judgment?
At note I am reading about section 138. 138 is summary proceeding.
Yes.
I am trying to the judgment second.
No, no. Which paragraph you are relying upon? Which portion of the judgment you are relying upon?
Unbest. Para 18. Para 18 it starts from para 40 and 13 onwards, verse 11 and observe that 13 page 5 of philosophy.
Yes.
Go below the act on the point of restriction, legal requirement is mandated under 130 Act and not be put by the complainant yet by bringing that up. Which is the fact of the matter.
So if the London court is of the view, if the agreement is not proved, why the question was put to the accused? If document was not proved or not produced before the court during the trial, how the question was put during the procedure in the 313?
That, or that's why I will hit on the court. That the court knows very well about it. That well goes judgment asked to favor the accused keeping the and that the chance that two meet can be possible. When it should be accused, that degree. Now you are not sick, anyhow you are not sick. The court has put that question. Anyhow, where from it has come, that was the matter of ship, but the court has to give thing. Now you are not sick. For that also, the question that has been put has to be some base. That base has not been discussed. And second, the it has a place that the legal aspect has to be through the complaint. Yes.
Okay, let me hear.
Yes.
My lordship, as my lordship has noted, lordship may kindly come to page number 32.
Page number?
330.
Page?
32, my lordship, in the paper.
Correct. There's a 313.
Yes, my lord. 33 page number. Question number 11, my lordship. PW1 complainant further reports that on 5/12/2016, you being the proprietor of Island Gateway Property Developer, Friday Inter-Indian Agreement, a complainant to purchase 65 plots from the said property at a consideration of ₹65 lakhs. What do you have to say in your term? So here the answer is, so the agreement was accepted, and what happened, my lordship, in my bond I mentioned that the original was kept by this accused person, my lords, at the time of execution of that agreement. That's why we are not in a position to produce the same. And
Why you're not invoking section 91 of the CRPC for production?
sorry.
Why you not invoke the section 91 for production?
So the next question, my lordship, question number 2. Complainant, PW1 complainant further report that on the case of agreement on 5/12/2016, he received check of ₹3 lakhs and ₹1,50,000 to the complainant as earnest money, and out of which ₹1,50,000 was in cash, and it was agreed that the registration shall be completed within a period of 90 days. What do you have to say in this, in your support? Once again, he has accepted. The transaction is very much accepted, my lord, in the 330. And the next question, question number 30. PW1 complainant further report that it was subsequently agreed between you and the complainant in the case that you will pay ₹10 lakhs to the complainant and remaining some addition. What do you have to say in your support? Here also the answer is yes. So here the accused person, my lordship, yes, accepted, my lordship. There is a legally payable debt is there. And now I will come to my grounds, my lordship, because this accused person, my lordship, opportunity has been given to him to agree the evidence. As the original report is before, my lordship, but he chose not to appear. That restrained me, my lordship, to do cross examination in respect to all these questions. Because he voluntarily, ample opportunity had been given to him, but he chose not to appear, stand BW. So my right was curtailed, my lordship, in respect to.
By not allowing or not produce the DW can be a ground for conviction.
My lordship, please take, I got some judgment, I will come later on. Regarding.
Okay, you argue on your own way, no problem.
Yes, thank you. Because, my lordship, the judgment dated 28/2/2020. I will say the Leonard 40 not consider overlook, my lordship, the basic legal aspect of Negotiation Instrument Act of page number 82, my lordship, of the paper.
Yes.
Of section 180 presumption as the negotiable instrument, because in section 118 there is a consideration clause in there. And here, my lordship, the consideration is a case is only based upon it to pay the balance consideration amount. Now my next ground is, my lordship. Here the accused of my lordship failed to prove presumption as to why the check was issued by the accused person to this company. And the next is, my lordship, the accused person during trial also the trial presumption in favor of the holder of check as per section 139 of the Negotiation Instrument Act. Because choose not to produce any evidence, the presumption is in favor of the holder of check, due course, my lordship. And the next ground is the section 139 of Negotiable Instrument Act is reverted to the accused, whereas the fact remains that the accused did not choose to examine any witness as to why the check was issued to the complainant. And thereafter, even this accused person, after receiving the legal notice on 4/2017, he should not to give any reply. And because in the 339 notice, he was saying that since the complainant was dealing with some other person, Arun Kumar Agarwal. That's why he is not interested to pay the balance amount. But this accused person will also at no point of time, respondent number one, taken any steps for stopping of the payment in the bank. That was not done. If at all he's saying, my lordship, that this complainant has already contacted Arun Kumar Agarwal, so I'm not in a position to issue the to pay the balance considered. But this accused person at no point of time made any reply in respect of the legal notice which was received. Legal notice is 4/10/2017, and he received the notice on 5/10/2017, the next day, my lordship. And during this period, my lordship, from 5/12/2016 to this day, until the issuance of this legal notice on 4/10/2017, at no point of time, my lordship, the 30% issued any notice also. This complainant is regarding all those points that we don't want to make payment or we take any attempt to stop payment in the bank in respect of the check. That was not at all done. And moreover, my lordship, at no point of time in the trial, the accused person challenged his signature in the check. And thereafter, my lordship, the accused person is the respondent number one. Going to prove, my lordship, how the check of his check was under the possession of this complainant, and he did not take any step either writing to the bank or making a proper publication for law of such instrument. That was not done. This is also my one of wrong. I did say, my lordship, there was a runner told fellow did not apply any judicial mind by passing this judgment dated 26/2/2020, 28/2/2023, my lordship.
Okay.
Thereafter, my lordship. The store now, as already stated, my lordship, the complainant was able to produce the agreement. That's right. His case was rejected.
Yeah.
Now, my lordship, already have stated in 313, the accused person, the respondent over here, he admitted regarding the agreement, regarding the payment. So he got, my lordship, legally debt. He's legally bound to pay, my lordship, to the complainant. The next round is, my lordship, the presumption, my lordship, it is in favor of the complainant, because at the time of DW, this accused person should not to produce any witness. So he failed to prove, my lordship, his case. There are number of Supreme Court judgments also there, my lordship. I will produce some of the documents of the judgments. First the judgment is my lordship.
Still your Indian Kanun.
Yes, my lordship.
Still you are harping upon the Indian Kanun. Huh? Not to harp upon the Indian Kanun, sir. Yes.
The first is, my lordship, my first three judgment is in respect of the three criteria.
Where is that? Which paragraph?
I will show you. The first one, Darinder, for the state of UK and others.
Dharnidhar.
Page number 6, my lord.
Page number
6, my lord.
6.
Yes, para 24, it is the continuation of para 24 in the lower part, first, second, third, fourth paragraph. Therefore, there was no education injected this pattern.
Where from you are reading? So there is no para.
Page number 6 of para 4.
Page number 6.
Yes, then pagination for the convenience.
That is the page number.
First judgment.
First judgment, Dharnidhar. Yes. Page 4, page 6.
Yes, page number 6.
6. Paragraph
4, my lordship.
Therefore, we have no agitation.
Yes, my lord.
Hmm.
Still another aspect of this case is the provision that were being examined under section 336. They badly denied the incident and stated there were planned incidents. No evidence in that cannot question accused by the accused person, even if the statement is assumed to be correct. Our accused cannot turn their back and deny the existence of dispute between the parties. This would further be one of the links in the chain completing the track of fraud. Besides giving a gender denial even to the basic fact that in the last to proceed put to them by the court. The statement under section 313 of the CRPC stated that the vehicle extra are from the same family they have falsely given evidence against them. We also state that the vehicle and the family of the accused doctor to grab the land. Therefore, they have falsely indicated them in the present case. It is a settled principle of law that the statement made by the accused under section 313 of the CRPC can be used by the court to the extent that it is in line with the state of prosecution. The same cannot be the sole basis for conviction appeal. In the present case, the statement of appeal before the court to some extent falls in line with the case of the prosecution, and to the extent that the case of prosecution can be sustained.
So how it will help you? Can you see?
My lordship, in the 313,
It is settled law. It is settled principle of law. The statement made by the accused under section 313 of the CRPC can be used by the court to the extent that it is the line with the case of prosecution. Correct? The same cannot be sole basis of conviction
yes, my
of an accused. In the present case, the statement made before the court of the extent the false is in the line of the case of prosecution to the extent that the prosecution can be substantiated and written as corrected by the court. So how it will be help you? So how you are corroborating this judgment with your case?
The importance of the 313 has been mentioned.
Okay. Next.
The next one is whether the legendary thing was the state of empty.
What you are citing that Mr. Savir is harping upon.
Yes,
Yes, paragraph.
parameters without 10.
Paragraph 10.
I believe.
Hmm.
The settled principle of law that the statement of practice and its 313 CRPC can be used as evidence against accused into further to support the case of the prosecution. The same thing I believe. Equally true that the statement and the 313 implicated normally cannot be made on the basis of conviction of accused, but by the statement of that accused and the 313 is in line with the case of prosecution. Certainly the heavy onus of proof of the prosecution is to be some extent reduced.
Yes.
Respect the recent judgment of this court in the case of Ram Naresh and others. The state of Chhattisgarh being one of the very this court and defended. In terms of section 313, the accused has freedom to maintain salary drawing the investigated as well as court. The accused may choose to maintain salary of complete denial even when statement under section 313 is being recorded. So the court could be entitled to draw national service, including advance evidence as may be permissible to in accordance with law. Right, here my lordship. Accused did three, once again, I want to repeat the accused at the time of 313, he has accepted regarding the execution. It
Yes.
is not that he has denied it. And in the cross examination of also my lordship, that nothing is found to disprove the case of this complainant, my lordship.
Yes.
The next judgment is my lordship. Tribunal order versus state of Karnataka, West Bengal. Para 13, my lord.
Is also 313.
One is, yes, my lordship.
Paragraph 13. Paragraph.
13. Point.
Yes.
Therefore, shows that the appellant, Guru Mohammed was present at the time of confidence according to his own condition. Not only that, he had according to his own statement participated in even asserted the belief double. Before plead from the spot. The statement of confidence and the can be taken into consideration is not a issue. Not only because of what section 313 section 4 of the court provides, but also because of the law they belong to this court in several cases. Even in this regard, refer to the region of this court in Janathan, Askar, and another with the state of West Bengal, that is court of them. And here also, my lordship, in the para 13 is very clear, my lordship. Here, there is a admission to the accused person in prison.
Yeah.
Now, the next judgment is my lordship. Para 18 minutes.
Para 18.
18.
This is with regard to what proposition? The 13.
Presumption method.
Presumption.
This is regarding presumption. Section 139 of the NI Act.
Yes. Paragraph
18 method.
yes.
Considering the fact that there has been an applicable business relation between the parties, here also may not there is a business relation. We have opinion that the different based and appellate does not inspect appearance or meet the standard of the confidence of probability. Absence of any relevant technical success was the transport enough. Whether in this party the appellate depends on according the other report on this self-protection meeting. On under definition, it's a one-sided failure.
Yes.
You know, the law actually of the secretary here, the judgment was secretary may not say. That judgment is my option. That will be seen. Much of it is.
Which paragraph? What presumption?
Yes, ma'am.
Paragraph
Is. Para 5 minutes. Regarding free technology.
313.
Here, what happened when was it loan was given for 2 lakhs rupees something. And he has denied that I actually proceed for the asset for. So that is like in the para 5 minutes. The accused in his statement and the of the CRPC article. The complainant running a loan from activity denied the rest of the complainant's case, stated that he acted over a blank check to the complainant. Because he has taken loan which for cheap. 1,000 of credit. He did not make a payment of these 2 lakhs because they have not done any obligation to pay his fund. The complainant wanted to extract money from the accused by practicing fraud account. Examine Chief Ram Sharma and his defense. Failed to tell the there is a presumption under section 118 and 139 of NI Act. The check was issued in discharge of legal liability for valid consideration. The burden fixed upon the accused to revert his presumption. And here by also for the presumption, the accused got legal liability might also pay the check amount to the company. Last judgment is Rajesh Singh Joseph Ajay Singh.
Yes.
Para 9, page number 1. The statement under section 330. What's it got it?
Yes.
So 330 before of Bill 1970, the accused admits of having borrowed money to the extent of 50 lakhs in payment. He admits of having paid some interest amount and stated that he did not pay the remaining amount. His complainant started demanding higher amount. He further admits of having issued the legal notice of finance, having issued check notice. And no evidence, defense evidence has been read on behalf of the.
Yes.
Same lordship, the appeal was allowed, the last para, and same lordship, this accused person is legally bound because there is a transaction was done. And the plea taking we accepted it, there is a presumption is there. And in order to prove his case, he never agrees any witness. So if same lordship, the second date, 2023, maybe set aside.
Okay. Yes.
Already paid.
Mm.
Order passed by the judge, part of. Page 17. Never. Yes, that is
Yes.
a perusal of written something filed as well as evidence scheduled by the government. Evidence that one agreement was stated in 5/1/16 was executed between the complainant and the accused person. Further, it was case of the complainant that in terms of said agreement, the first is not on the legal ground, but on the basis of this legal agreement. I should depend. If there is any terms of it, there is a dispute with regard to the answer, and the state exercise was
It's one direction and there was a dispute between the sale agreement. It can create a presumption that that is the reason why company deliberately did not produce the sale agreement. So the legal basis that sale agreement.
Correct.
Now you are in simple, the complainant has to prove that there was an agreement between the complainant and the accused. Thereafter it becomes the burden of the accused. The child is not coupled with any liability on the part of the existing terms of the agreement. So your lordship, the prosecutor proceeding your lordship may know before your lordship that in this the legal mandate has been fixed by the statute. What is the legal mandate? So the time period and this legal that is almost not only if the complaint was that the check was for something that liability and the check was for that presumption thing can be taken into account. But here the basic foundation is that agreement. On the basis of that agreement, also the check was.
So your case is that the case based upon the agreement,
Yes, sir.
and what the total case is made upon the agreement. The agreement has not been produced. It is not proved. That's why the London magistrate has passed correct order. This
Page
is
77 and the judgment.
that's all.
Yes.
Thank you. Thank you.
The government of specifically stated by lordship that the vigilant of sale agreement dated 5 to 1 was rectified. This accused person, that's point number 10. Because this-
Where is the cross examination on that? Where is your case made out?
That's why I'm not-
In the complaint, where is your case made out that the original is with this so and so so and so? Then,
There is, either because not at least I was trying.
but you have not made out the case. Okay, let us see. Hearing concluded.
Okay.
See. Yes, next.
When it does the file comes to the file will- Equivalent and the chairman of the HED component.
Where is Mr. Balan?
These are very often. No, the portal category from any of that and later. Or any scheme on that. No, it's more than. That's also from that one. It is very later.
Okay, Paswa.
In one.
Item 9. Yes. Why?
Order number 2. Second order by Honorable Justice Majlis Prasad.
Order dated.
Order dated 7 January 2025.
From the Parliament, they would be taking steps and implementing the Secretary Revenue as party. Appropriate steps be taken. Yes,
My
then.
lord, on this case, the respondent, private respondent.
You are appearing for whom?
Private respondent.
You are for the private.
Yes.
Who is for the petitioner?
Meaning finance.
Ah.
And on particular date, we had raised the maintainability. And petitioner had accepted the same and intimated that the order has been passed by its deputy commissioner. I will be preparing an article.
Correct.
And he had sought for time bound direction for the appellate authority. So the honorable court had directed her giving liberty to make a party secretary revenue. Now, my lord, can you see next orders, my lord, January 9, 2025. Petitioner had sought for that.
Correct.
January 15 again time. January 28 again time. February 6, 7 days extension. On February 18, by filing a CAN application, not by this honorable court, petitioner herself had admitted that they will be preferring the appeal before the appellate forum. So they had filed a CAN 1 of 2020, which was also allowed by this honorable. The ordering portion is at para number 5.
According Secretary Revenue Portal is added.
Started as a party.
Correct.
Direction was given. Make them implement them and affidavit of service on February 18, 2025.
Correct.
Now, without following that, on 3rd of July 2025, they are coming up and making an argument of deputy commissioner, but
They are not made a party.
yes, they had made a party section
So?
revenue member, but they have taken an alternative forum. For that same reason, they had made a secretary revenue as a party and a coordinate bench directions are there. And without going there, now they are coming up for the deputy commissioner.
Why the secretary revenue has made a party here?
Because for filing an appeal, my lord, the regulation.
Filing an appeal, secretary revenue is required to be a party.
But
Have you
for that
prepared an
only they are
appeal?
prepared.
No,
So,
but I have prepared this petition because there is an illegal order. My lord has already.
legal order. So why you file an application for adding the secretary revenue as a party?
Directly, so in that.
No, you have filed an application, kind application.
But there was an order. There was an order. I made them as a party.
No, kindly come to the order dated 7th January. And at council for the petition submission, say you taking steps for implementing, you made a prayer. Why secretary revenue has made a prayer?
The honorable court has instantly to file this petition. Let's say I filed it. But this petition, it is maintainable. It is maintainable. I'm arguing that it is maintainable because there is an illegality in the order.
What illegality?
My lord, kindly see the deputy commissioner's order, my lord. At page 31. What they are saying, my lord. After reviewing the records and documents, including the affidavit and form date. If the affidavit and form date, if it is a correct one, the deputy commissioner, what he has to do, my name has to be struck off. They have not done. The record is in the name of brother and sister, my name and as well as the private correspondence name. So now, if otherwise what he has to do, he has to struck out the remarks part. He has not done. He said, if it is okay, if it is admitted, my lord, if it is admitted, then my name has to be struck out. Then I could have filed appropriate application. They have admitted everything.
An affidavit or petition can the right can be relinquished of the ancestral property.
Well, that part I am not at all. Because my only contention, because one coordinate else the petitioner is submitting.
No,
on
he has
the
made
subject
it.
regarding is not.
Where is the mentality point?
Yes, my point. It says we had raised for that.
Where is the mentality point? Where is that?
January 7 of
7 January only she has stated that she will make implement the secretary revenue as a party. There is a delay.
reason was for the maintainability point because we had raised my.
Okay, show me that mentality point. What you are raising the mentality? Show me the mentality point. Argue, I will take that.
Yes.
Argue, you are raising the mentality point. Let Mr. Lokesh conclude the argument, and I will come to the mentality point idea.
Yes.
On what?
28.
Yes, on 28, yes, it's in the second appeal is like before the secretary revenue, no problem. But kindly come to the order. He's telling that this order of the deputy commissioner is totally illegal beyond his jurisdiction. Then
Yes, then I come. There is another regulation.
what regulation?
38.
Review.
38 surplus 4.
What?
Before my lord.
Give the and revenue reform. Regulation 38.
My lord, prior to that, kindly see the petition. Page number 20, annexure P2.
Which regulation first which regulation you are talking about? 28 is the appeal.
Yes,
Then
30,
30,
38,
38.
38. Regulation 30.
What's this? Regulation
Yes, ma'am.
38.
The application has been filed by the writ petitioner under regulation 38 subclause 4, where a dispute arises in respect of any subsection.
Where 38? Regulation 38. Chapter 5.
Chapter 5. Yes, my lord.
Which clause?
Subclause 4.
Where the dispute is in respect of any under section 1 or section 2 of section 3, the dispute shall be decided with the deputy commissioner.
Deputy commissioner, my lord.
Correct.
Now the next point 5, my lord.
Point 5 years.
Any person aggrieved by any other class in the subsection to institute a civil suit to contest the validity of order within a period of 1 year from the date of such order.
Correct.
Now, my lord, kindly see page number 26, annexure 4 of the writ petition. Of their writ petition.
Page 26.
Yes, my lord. Annexure 3.
Yes.
to my lord subject under section 38(4) of the Andaman Nicobar. This is their application of 38(4). It was decided by the Deputy Commissioner under 38(4). Now the client under 38(5) without going there, they are approaching the police honorable court. How it could be maintainable, my lord?
If the name is struck out, then I have a right to go before the civil court. Here, name has not struck out. They have accepted. They have accepted the deputy commissioner point. Yes, to do. If he is accepting that 1,000 square meter is correct, that affidavit is what
That's
is
why,
correct.
that's why, that's.
Affidavit, my name to be struck out. To be record. Or if he is admitting, if he is not admitting, then 1,000 square meter has to be. He has not done anything. He has not done. He has simply said the affidavit and form G has been submitted. And it has been done.
Correct.
So what civil court will do, my lord? All the records are here.
That's correct, madam. Yes, see, you had applied for the mutation of your own, requesting the Tehsildar to only mutate the 1,000 square meter of land in your name, remaining in the name of your brother. Correct? The mutation was held, whatever it is, you are not challenged that mutation. Subsequently, once upon a day, you woke up and filed an application before the deputy commissioner. Sir, it is wrong. The deputy commissioner has called for the report of the revenue authority and found that you have given the affidavit, you have given file an application, whatever it is, the Tehsildar, the deputy commissioner has not invoked his power for recalling of the order of the Tehsildar by giving your share other than this 1,000 square meter. And you filed an application before the deputy commissioner on 38(4). Correct. And when it was not disposed of, this court has directed the deputy commissioner disposed of. As per the past, correct, as per law. Now the deputy commissioner rightly or wrongly has disposed of the application, has not interfered with the order of the Tehsildar of the mutation. On the ground that you herself had made an application before the Tehsildar for mutation of only 1,000 square meter and the remaining should be mutated in the name of the brother.
That is wrong.
Well,
I have given the form date is written, the entire land should go to my brother. That is that. Not 1,000 square
okay,
meter. That legality.
okay, you go to the civil court and apply your writ.
Well, here, the document. What
How the writ court can decide this?
kindly, the affidavit portion, the affidavit cannot be entertained, my lord. By the
That's why you decide.
second thing, my lord, kindly see, my lord, what it is written in the form J. If I have, because the mutation, if I am not getting any land, my lord, why I will go for mutation, my lord? That is the thing. Why I will go for this mutation?
When the mutation was held,
Not that they are saying,
then
they have filed this mutation,
97,
97, my lord.
97, and you file an application 23.
23, because in the year 21, when my children, they grown up, they wanted to subdivide the property because in the remarks column it is mentioned 1,000. But my lord, see in the armor, both names are there, my lord. Both names are there. So I am in the impression that it is in the recorded as per the Hindu Taxation Act.
Correct.
Both names are there.
You are right. You are right.
But when I came to know in the year 2021, kindly see I have applied for the certificate.
But how this court can pass an order at this stage in the order of the deputy commissioner? How the court can decide what you are entitled, either the civil court or you get the appellate authority setting aside the mutation order. How the writ court can set aside that?
But when the authority is saying affidavit and form G is correct, then he should have what he has to do. He has to struck off my name. He has not done so. Yes, he has to struck off my name.
Why?
Because the reasons what they have given. The records of documents including the affidavit and form G, the undersigned finds that the mutation was carried out correctly. So they have admitted that yes, affidavit and form G is there. So my name should have been struck out. I should have filed the civil appeal, challenging my right. They have not done so. Or else they have.
Who is appearing for the authority?
And kindly
Yeah.
only.
Can you produce the revenue record of the mutation proceeding? When?
Yeah, for tomorrow.
Mutation proceeding of 97 because it might be because the deputy commissioner relied upon.
Well,
Produce all the revenue record.
I know.
RC number. What is the RC number?
File number WPLC.
No, that is the deputy commissioner file. With regard to your mutation, because the form J and all the things the deputy commissioner considered by which record he has considered on or only on the basis of the report given by the Tahsildar or the Patwari.
The case number is not mentioned.
408 of 97, what is that? Page 34?
One report is submitted 36, page 36. It was submitted during the
2024.
hearing before the deputy commissioner.
That's why I'm asking whether the deputy commissioner has considered the record or only on the basis of the report. If only on the basis of the report of the Tahsildar and not concerned with the record,
And in the report itself, it is mentioned, changes.
okay. No.
State itself.
No, why is that all the things is kept on record?
167
Record. Mr. Lokesh Cherin, an advocate appearing for the private respondent. Private respondent raised the point of maintainability of the application. Maintainability of Mr. Cherin submit that the petitioner has filed an application before the deputy commissioner under section 30, under regulation, not that section, under regulation 38 within bracket 4 of the Andaman and Nicobar Islands Land Revenue and Land Reform Regulation 1966. And the deputy commissioner has disposed of the same by passing the interim order dated 27 November 2024. Mr. Cherian has brought the attention of this court to regulation 38 within bracket 5 of the ANN LR and LRR 1966, wherein it provides that any person aggrieved by the order passed under section 4, under section 4, action sub regulation over subsection B, may institute a civil suit to contest the validity of the order within a period of 1 year from the date of such order. This court, after hearing Mr. Cherian, find that the deputy commissioner has passed an order on the basis of the report of the Tahsildar appearing at page number 36. But this court intends required to see whether the mutation proceedings, a record of the mutation proceeding was placed before the deputy commissioner or only on the basis of the report of the Tahsildar, the deputy commissioner has passed the interim order. Accordingly, the Mr. B.D. Sivalan, both are appearing.
Yes, sir.
Mr. B.D. Sivalan and Mr. Arun Sandhu Kumar appearing on behalf of the authorities are directed to produce the produce the record of the mutation proceedings relied by the deputy commissioner by passing the said order. But
Advay, the one.
by 10th of April 22. 10th of April.
And can it be on Monday? From
You think mail message. हाँ, 10th June 2020 July. हाँ,
plain copy.
why? Your will not consider by the if you impress the administration to keep the file, so why you
I just see the contest.
call the person?
Yeah. There. I'll give it.
Yeah. What's the matter comes to?
In property invoking regulation 152. Holding that for the last more than 1 year cultivation of not done.
The resumption.
So they were supposed to place the record.
Yes,
So it's in nature of
Bala.
very held before passing the input.
I produce the recording. There also.
Yeah.
Balan, where is the report? On the basis of this, has been initiated. Go to the first POC, report is the Patwar.
It is there. And
Report. Where is that report?
in the end, it will be the last. I think I have seen. And
And what purpose you want to resume the land? What purpose? Any public purpose?
Manor,
What?
playground.
Playground. Already there's a report, they are using the playground.
Manor.
If you want, they could have acquired my property, but not this way, not.
Where is the report?
Manor, let me check.
Give. You are not going through the file
I know.
before placing before the court.
Report which is there.
Yes, Mr. Jaipa. Businesses during the inquiry.
On that, they will not get taken. If it is an amendment only under regulation 152. There has to be one examination.
That's correct. That's correct.
Statement will not kindly appreciate one thing. I have placed all papers.
You show one thing,
thing that I am saying this operation of this order. By the affidavit disclosing all the documents,
He then buy this.
find it, but you not disclose this in the opposition.
Not,
I have not annexed it.
subject to what my law is, so they could scoop pending. Self and property, status quo is there, and my lord to see when the order was passed, after the status quo was passed. Let the, I will make the subdivision officer the party in this, let the order goes, then the team to decide, they can make this point in the suit. Not to see the subdivision order, which are challenged here, they record that in the status quo order. But 152 cannot be invoked in the way it has been done in the present case. It can't be moved. Article 300A is my fundamental right. But they want to take my property, take the due process of law. Take judicial proceeding on, not in this way. So they cannot have the cake and eat too. Take my property, give me compensation. 150 is easiest way to take the property without giving compensation. And not nature and standard of inquiry as required as contemplated under 150. It's not like simply sit or mutating, calling for a report from the mutation. There has to be a complete material on record to show that no application was done. How this could be ascertained whether in the soil? The last 10 years, the statement of the co-players comes into aid. One meeting is very, they have directly in nature.
And who are they? The petitioners are in occupation.
They are in occupation. They are taking land revenue.
So this inquiry report has been filed.
They have taken this point. The report was not given to me.
They are not in. Report is there.
I think
Yeah, but
status quo as a nature character possession that to make it. That's showing that clients on the first day in this school, they want to take the property. Short term must be put in the not correct. It was falling from this school because they were going to take the property on short term.
yes,
After opposition, we have. Like this. 822.
How
I can take this serious to the order of the status quo, and you are authorized. You are not of the civil suit. That's why you are not as the status quo order passed by the court. What is that?
That direction order is not, but we are not the party in the. suit.
Correct.
Civil
You have aware of civil suit order. It is placed with correct.
My lord.
And it is depicted in the impugn order.
Yes, sir.
But your authority stated that we are not confined to the suit. If you are not confined to the suit, whether and if the court order is with you, before you, what is your duty? Being the officer, it is not a layman, then what can be done?
My lord, since the petitioner were not in possession, since it is a vacant land, the department has taken possession. And the record also billed in the name of the revenue department.
So, any further submission?
They have not filed any affidavit in reply for opposition. The order passed by the subdivision officer is also an applicable order on the point of maintenance also. The application is not
Under which provision?
38.
It is under
28, madam.
with the under
SGO.
the same officer would be the appellant for.
No.
SDS passed an order.
My lord.
Then SDS passed an order under 152.
My lord,
Then
it will be to the chief commissioner. Subsection 2,
subsection 2 of
regulation 28.
then
That is, the petitioner has no local standing, my lord.
Hmm.
They are neither the legal heirs of the family members. And the principal of
so if a private person occupation of the property and the suit, there is an order of injunction, that would be effect of passing an order under 152. What would be effect?
The suit would go, Lord, the entire suit would go.
Effect. If a private party claiming the land and you had the knowledge and the suit, there is an order of injunction and you pass an order and clear the make the record in your name, what would effect of the suit?
the private party claiming any document, no, did nothing.
That is the civil suit. The writ court cannot decide. But your authority is clear.
My lord, my submission is that the application is not maintainable and they have to, the department, no violation of principle of natural justice has been done.
Hmm.
And the order passed by the sub-regional officer is appealable order.
That's all.
That's all.
So that
Just one thing, Lord. Lord, the judgment of Supreme Court is very clear. Natural justice not complied with this part of the operation. Not the
entered appearance in that before the no before the,
HTU, they have published the notice.
they have published the notice when you entered up
So it's on 20th of September 2020.
because there is no revenue sheets.
Lord, page 55 may kindly be seen, Lord.
Order sheet.
20th of September 2022. And against the record publication, I raised this objection. Before the interim order was passed. But see, at page 55 of the resolution, then I filed this to obtain the status quo order, then they passed the interim order.
Page 55.
55 petition.
Before the publication.
55.
56.
55, 56.
20 September.
Yes, Lord.
When the publication was made
Is dated 7 September 2020.
and you entered affair and you have given the objection on 20 September. Then
That was not the interim order was passed 8 October 2022. My suit is, and the interim order is 27 September 2022. This sequence is of September 2022. Application of action suit, September 2022. They passed the interim order, October 2022.
okay.
But to pray for setting aside the order and the constitution step taken, recording the revenue, that gets to be stuck. That's what we
At the London for the parties, hearing concluded, hearing the report produced by the by Mr. Garan, we can with the report.
Again.
Yes, next.
Petitioner in this with ten. Yes. 24, 2024.
8.
24 by the police of P. Start- uh, Just- Well, just it's it got charge the case of NDPS, the credit petitioner is which are concerned officer in charge of the so the- was like did madam how many and smart again your kind attention 16 it was 18 like complete with so एक machine है I'm just basically kindly guiding some coming This is the turning point of the case, page 20. This is section 50 is issued to the accused Atish. And kindly see the timing. It is on 24/8/2025. Received. When the reading was not done, they did not proceed to this position. Taking hours.
Yeah.
But the proceeded attack and the investigation came up from that place. But in the present case, show that there is some manipulation with regard to the document.
Yes.
In this case, I examination of the witness in a single case, so that I can control those witnesses and I can pray for bail. But unfortunately, I use this word. Out of the 7 accused, 1 accused came up with petition for discharge under 220. That petition is also pending because
But the state
25.
frame.
Not framed, not yet framed.
But petition is pending.
In the month of March 2025, the discharge petition was filed. Now, my lord, this accused is a family man and this is the first offense of the accused. There is no previous incident. In any manner, I can very candidly submit my lord, not even a plan against this accused person. He has 2 3 children and the age of mother died long back. And if and mother is at resident, there is dispute regarding it. I will close the ID card of the
Yeah.
then also my lord.
Almost.
The way the petition people, there are 7 accused persons. Against 6 accused persons granted bail. Against someone 29 section NDPS, the abandonment conspiracy, for that is there on referring to the all 6 accused persons granted.
No problem.
Here, the highly seeker direct possession, seasonal constitute in this position on information. The police chief constituted list on the spot and it was given to you that we want to search you after convolution of entire formality. We have tested and treated those heroin. It is a commercial quantity and there is the bar under section 37 of NDPS.
Are under section?
37 of NDPS.
There are certain riders, my lord, this court can impose condition under that rider. There is no strict ban under section 37.
Yes.
There is a what reasonable question. That is what is being used. So what is the private mistake? Or you kindly see the reasonable. From this position, commercial quantity of heroin in Andaman and Nicobar Island was found first. Second part, my learned friend has pointed out regarding that timing loss. But see, that can be decided at the time of trial loss. At this stage, from framing of charge, while interested, it can be taken advantage by the accused person at the stage of trial. That is 10 hours and 10 hours. That is can be attributed during trial. But prima facie, it is found that it was directly commercial quantity heroin was found from the possession of this petitioner. So at this stage, there is a bar under section 37 or 3. I oppose the way of the exceptions. I am.
My lord, may I just give a reply yes, after the leave from this honorable court. My lord, my brother has said section 37. The leave of this court, I may be about to read it, my lord. Any
Yes.
offense punishable under this act shall be cognizable. No person accused of offense punishable for offense under section 19, 24, 27A and also for offense involving commercial quantity shall be released on bail or on his own bond unless the rider comes before this honorable court. The public prosecutor has been given an opportunity to oppose the application for such release. That opportunity is provided. Where the public prosecutor opposed the application, the court is satisfied that there are reasonable ground for believing that he is not guilty of such offense. I'll pause this court for a moment. The discrepancy of timing in the notice and the information receiving timing is absolutely prima facie shows, my lord, that there is some manipulation
But
with
Mr. Rakesh,
my lord.
kindly come to the See,
My lord.
it is on 24th August 2024 at 8:10 received an information, but it is not that 8:10 the notice was served. Where is that? 18:10 the notice was served. 18:10.
My lord, may kindly see the timing in the 42 compliance, which is at page number 19, my lord.
90.
My lord, may kindly see the time mentioned out there.
The credible information.
And my lord, the reference to the report which I have placed before my lord, page number 16. This is the report of the department complainant. Referred, my lord, to that particular portion also.
Oh,
Time to time, how they proceeded after this.
okay. Yes.
And since my lord, charge sheet is there on record, there is supplementary charge sheet awaiting. There is a discharge petition. If I'm released on interim bail by imposing any terms and condition, being the local resident of this island. And the prosecution and all the witnesses, my lord, may kindly appreciate they are the police witnesses.
Yeah.
The rating member of the team.
I have a judgment of Vihan Kumar. What is the date of that judgment? You know.
11th June.
Yes.
Judgment of my lord, what the my lord is calculating from regarding grounds of ours.
That's why I'm asking, but you have been arrested in 2024. August 24. Judgment is in July, February. That's the, that is the problem. How you can come out from the 37?
But kindly see, there are riders, my lord.
That's correct.
There are riders
37.
and it is code financially satisfied, my lord, because there are timing, mistiming in the 42 compliance as well as.
Where is the report? Chief Secretary, report of
Something seal. Opposite.
when it was sent. When it was sent to the CFSC?
Just like a.
Yes. Come tomorrow, come tomorrow. Yeah, dinner will be, no? When it was sent?
Just.
Give it to me.
Just 5 minutes. Will give it.
Give it to me. I will. When the arrest was, when the seizure was made? 28/4. 28/4.
Not said the
28.
24/8.
24/8. You are not having the rule? You are having the rule, NDPS rules? What time it has to be sent and what time the report has to come on record? Oh, the rules says what time. There is a notification. NDPS rules, there is a notification. Yes, Mr. Kabir, it's notification. You're not having. All the procedure has been given there. Because inventory, how to send, what time has to come, what is the time limit for submitting of the report. There is a notification of the government. Even the videography is the permit, is the mandatory on that. Where is that? Where is that? That all the things have been provided. That's why I'm telling when you will be back. Full report is there. You all persons are not carrying and conducting these NDPS case. That all gone. Now we have to, with regard to the rules.
13 dispatches sample, the sample should be sent directly to.
Directly. And within 15 days.
Control rule, 14 is exponential stress, chemical authority shall submit its report to the magistrate, the copy to the RO within 15 days.
15 days. Whatever, but you, the defense counsel, to be careful. You are not, also not having being a public prosecutor. Good sign. You have to go through the rules. Procure the rules. I will pass you now. Let the junior appear. Tomorrow. At the London record and order, at the London counsel for the prisoner and the public prosecutor. The public prosecutor is directed to produce the rules framed under the NDPS Act by tomorrow. This is the matter tomorrow. Under the meeting, sir, bail application. Yes, next. Maybe done this, yeah? और सीडीएस को वापस कर दो, सीडीएस को वापस कर दो, कल लेके आएगा. Yes, 11.
I appear for the petition.
What is the date? September 24. Yes, the same. Have you taken the when the report was sent and when the report was received?
That's the reason that the CD was not. And the
CD? Show the CD.
Case diary has been brought.
और ले लो CD तो. You are not received the CFS, sir.
But there are different occasions when the contraband articles were sent. Because the FIR was registered on 1st of September. And the arrest of these accused persons were made on 16th of September.
When he was arrested, when the Alamad this have been seized. When it was seized?
It was seized on
Lastly?
16/9/2024.
16/9/2024. When inventory was made?
Lord, may kindly come to the FSL report, Lord. They say that the date of receipt is on 10th September 2024.
Where from you got?
Lord, the report dated 29/10/2024, examination report dated 29/10.
Reference number 24.
Lord, kindly come to point number 5. Point number 5 says the date of receipt is 10th September 2020.
10th October.
No, my lord. My lord.
Date of receipt.
Yes. Point number 5, my lord.
Point number 5, 10th October 2024.
10th October, my lord. But I am having probably there is another. That is the reason I said.
Examination report number. What is the examination report?
Yes, my lord.
22, 26 or 24?
No, my lord.
The examination report.
No, my lord. It is SFSL PVR 191 CHE 191 of 2024.
Okay. How many reports are there?
My lord, there are 2 reports.
This is one on that is 11th October. Where is another report?
Yes, my lord. The second one I am having. It is on 11th of October, the date of receipt. And the date of seizure was 16th of September 2024.
Come tomorrow, come with the rule. Yes, next. Item number? Yes.
The injunction application was allowed.
Mr. Binu. This is the way the,
My lord, this is the copy I have received from.
the way they are providing certificate copies. Who is the authority?
The
Administrative officer. And comparing, call these both persons. Administrative officer and the comparing clerk of the district court. कौन है? कोई है? Administrative officer or comparing clerk copying section, वो दोनों को मिलाओ. Yes.
an injunction was allowed by the trial court.
Who is for the other side? Without notice.
This is not his appearing, my lord. If we accept the notice, I can serve and come back tomorrow.
Yes, sir, notice.
Serve and come back.
Petition. Record and notice. You will accept the notice?
Yes.
To come tomorrow? Petitioner has served the notice to the London advocate appearing for the respondent at the matter appearing.
One.
रखो आएगा तुम देखिए कलेक्ट हो. And next.
Lord, before I draw loss to the immune order.
I think I not possible for me.
No, this is not the matter. I think there is since. No, this.
Matter, the Andhra Association matter is also there. The property is also there.
No, not this property. Party may be the same.
The property with regard to the Andhra Association,
Yes.
that is also there. When there is a there was a litigation I had conducted against him.
There is some urgency, that's the reason, because.
Immediately I am sending.
You're not very problem, my lord. Kindly appreciate for limited purpose, not. You're not very problem, kindly see.
Due to personal reason, matter is released from the list of this court with the liberty to listen before the honorable court.
Okay. This matter and for the petitioner, petition this matter to please to direct me to file affidavit of service upon the private respondent. Apart from that, there are also lots of please to direct the respondent authority.
What is the record of revenue case? Who is appearing? Sivalan? Where is Mr. Sivalan?
The service upon the private respondents came back with insufficient.
What is the relief you applied for?
Lordship, I have challenged the interim order, your lordship, passed by the Tehsil in alleged presenting compliance of the Honorable High Court without any initiation of revenue case or any complaint as received by the private respondent as directed by the
Private respondent notice not served.
notice came back, your lordship, with the endorsement that insufficient address and also it has written that addressee cannot be located. Both
What can be done?
should order be passed to the part. I guess nothing.
The Sabine and advocate appearing for the petition submit that. The notice was sent to the private respondent by speed post and but was returned and as far as affidavit of service, let us then be. It is submitted that the postal receipt return answered with the endorsement.
Address cannot be located.
Address cannot be located. Address cannot be located due to insufficient records. Mr. Sabin and advocate should for time for taking appropriate research for service of notice upon the private respondent. And the first notice be served upon the private respondent and the file affidavit of service on the next fix. Next and it. This is the matter on Friday. Friday के 11 तारीख 11. Next.
And for the respondent, my lordship, let me Mr. Vinit.
Yes.
Election B part of cases.
Why you are not making demarcation? Why you are not conducting
I have
demarcation
to
after
take
receipt?
instruction, today only they hand over the.
That instruction.
I will take
Let's
it.
notice for the issue,
Let it be disposed of, my lordship,
the direction.
with some.
You are the
time.
recorded tenant. Pardon. The petitioner has filed the present application saying for a direction upon the respondent for demarcation of the land respondent, particularly the respondent number 2. For demarcation of the land bearing survey number 1 by P, taking an area of 0.50 hectare, situated at Abripur village at the Parganj Tehsil, southern Mandis. Mrs. Yasmin Begum, an advocate appearing for the petitioner submitted. The petitioner being the recorded tenant of the aforesaid landed property has applied for demarcation of the said land on 28th May 2025.
And if you keep
At the date, the Tahsildar was conducted any demarcation. Consulting the submitted role in council for the responding submitted, if a direction is issued from the Tahsildar will take up to register for demarcation. In the submission made by the council for the respective parties, the Tahsildar being the respondent number 2 is directed to conduct the demarcation as per the request made by the petitioner. By letter dated 31st May 2019.
Certification subsequently 25 also is applied. Election P5.
5 is 19. 31st May 19.
Is
Dated
20th March.
date is not. Dated 30th April 20. 30th April. Oh, that is the assistant commissioner settlement.
In page number 23, we issued a notice, my lordship. That is the application dated is written. My lordship. Page number 23, my lordship. Page 6.
Written back. Demarcated and itna. Where is that demarcation?
There are-
30th May 2019. After this, submitted to all site plot holders. Within a period of 4 weeks from the date of
Lordship, let it be within 8 weeks, my lordship.
within a period of 6 weeks.
Otherwise, they will come for.
6 weeks. 6
Yes,
weeks.
contempt.
Of the order. And completing this market, the report may be supplied to the petitioner within a week thereafter.
Lordship, since AO is not used, my lordship, that
And
case may be deleted.
the litigation is disposed of in motion district. No. Allegation made there in the WPS disposed. Yes, next.
So
Gandhi. Yes. Yes, belong. Just a minute.
Yes, please.
सिविल डिवीजन वाले अलग रखो बोला था ना फाइन with the comparing club how you are certifying this तो सर्टिफाई कैसे करते हैं आप लोग काला पेपर में नहीं तो कंपेयरिंग how it has come to you where is the that's why you call the comparing club ये कलर काला काला पेपर में आप जेरॉक्स कैसे हो रहा है आप सर्टिफाइड कॉपी करेंगे जेन्युइन एलिजिबल कॉपी होना चाहिए एलिजिबल नहीं होगा तो आप सर्टिफाइड नहीं करना है ठीक है Left. Yes. Yes, Mrs.
What has happened? First one, we granted by this court in the first round of litigation. Challenging it not passed by the customer under regulation of the routine. I filed a suit. The moment the suit is filed, it was informed to the Tahsildar about the filing of this suit.
Yes.
Now, the particular every now and then is administering effect of disposition.
Yes.
Because the judgment,
Yes, madam, once you have passed an order under
I
202.
deny the allegation that he's threatening the
No, whatever it allegation might be,
Might-
once the
civil
that
suit is-
civil suit is pending, automatically state, then
They have already, today morning, it has been informed that they have already given their brief history, parawise reply, and
I am disposing.
they're not going to evict them or any, they have.
Shall I record? Shall I record or take the instruction on writing? You take the instruction on writing, they are not going to,
Civil suit is, they have got the knowledge.
let them
And,
take instruction, then I will record that, I will dispose of. Otherwise, I will record your submission, tomorrow you will be in trouble.
Fine.
You tell them to give the 2-line report that they are not going to pass an evicting the petitioner as the civil suit is pending, then I will dispose of this.
Fine.
When? Tomorrow or day after? 11 तारीख को.
it is not only kind of it's.
The counsel for the and Ms. Babita Das, government trader submit that she got an instruction that the Tahsildar is not going to evict the petitioner, and the revenue authorities also came to know that the civil suit is pending. Ms. Das pressed for accommodation to take written instruction from the Tahsildar Mayabanda Tehsil. Accordingly, case is adjourned and the matter appear on 11 July. The interim order granted earlier is extended till 11 July. Take written instruction.
Fine.
Who is your senior? Gopala Binu Kumar. You are for the petitioner. Yes, you are having the building permit. Who is your private respondent? You.
There is no private respondent.
They made an allegation that the stay order has been passed, saying that they are not having building. So they made an presentation.
What construction they are making?
They are making.
Puja Pandal.
Shows that some.
For the Puja Pandal, this plan is required. Then I will keeping in month of October before the Puja package Puja. So I will see all the matter has been taken by the.
Stay order is there, but it should be proceeding has to be concluded. It's not passing the direction that the proceeding will be concluded. If they have plan, they will be. Saying
No, they are not telling the plan. They are telling that it is not coming under the purview of the building.
No, that's definition clause, it includes all.
Okay, let the building Kumar pass over. Or not today.
Yes, sir.
Not today.
Okay.
Next.
Yeah.
This, so far as 18 is concerned, madam, I request your doctor that your interpretation. Let me say this, it is a building, I have made a mistake because today I went to the LC. That day I did not go to the board. I'm not going to please look at 3:30 later. First, let me show you also the LCR, I am sorry. Can you take up the LCR first, the exhibit first? Last question, I was there to serve the copy because I got the complaint, is on my head. So the one, the flag, the green flags. The exhibit flag, only that one.
Exhibit 5.
Exhibit 5, and it will take only the exhibit one, the green flag one. From
Ah.
there I'll point out the page numbers, first is page 39. On top, on red, it is written in circle,
39 years.
exhibit 4.
Exhibit 4.
This is acquittals roll for April 2006. But we'll see in that entry, Dhiren Mistry, there is one person.
Dhiren Mistry.
Dhiren Mistry.
Inderjit
No
Das.
entry.
No entry.
Now kindly come to page 51. Exhibit 11.
Yes.
This is the disbursement of the money, 1,62,060 rupees.
60.
Kindly see to who it is disbursed. It is signed by the assistant director.
Assistant Director Maya Bandhu.
Assistant Director, Agriculture Department. Everyone has got that.
Yes.
Now kindly come to page 55.
No, but here received contents. Acha. Yes.
Page or assistant director. Page 55, next page. Again, the signature and stamp is of the assistant director.
Correct.
Now comes to page 69, exhibit 23. And page 70.
69.
69, 70. My handwriting is taken. My signature is taken.
Yes. 69. 70.
Okay, now my lord has seen my signature. Now at
Rama.
page 55, my lord will see that same signature that I have showed you lordship. It's not there anywhere in page 54, 55. Now my lord comes to page 71. Page 71, money is being disbursed, exhibit 12. Disbursed to who? Assistant director. 1,62,060. The money again went to assistant director. His signature and stamp is there. Now, my lord says next page, page 72. This is the most vital, exhibit 39. Now, this is the acquittance roll for January, February 2007. This is the main one. Now, kindly see page 74, serial number 22. Top one is blank. Top. Serial 22 on the right hand side. Someone started writing. It has either been interpolated or something has happened.
No, it is remove.
Remove. There must have been a revenue stamp which has been put on.
It's remove.
On the next page, kindly see who signs and maintains the acquittance roll. At the bottom,
Assistant Director.
assistant director and the person identifying is the Pradhan.
Pradhan.
My signature is nowhere. More importantly, kindly see bottom left. Refund of 3770 due to Dhiren Mistry. That serial 22 Dhiren Mistry. The prosecution complainant case was that his father was dead, but the money was taken wrongfully. This is that money. Serial 22. Amount is mentioned 3770. And what was the fate of the money? On the next page, page 75, it is written return. At the bottom, my lord will see. Right at the bottom on the left hand side.
Page
75.
25, yes. Includes concession, page 24, balance is not deposited.
Yes.
3770. Check number.
Amount of Dhiren Mistry.
Correct.
So Dhiren Mistry, the amount was not disbursed to anyone.
Correct.
Now kindly see page 81. Exhibit 40.
Yes.
These are the medical documents of Dhiren Mistry. Kindly see the date of admission. My lord, on the next page, that sheet is there from the hospital. Date of admission 16th March. Now, my lord, will see page 90 to 94, exhibit 25. The specimen signatures have been taken of the assistant director also. And after that, specimen signatures are there of two other persons. Total 3 persons have signed these documents. One is Assistant Director SB Singh. One is Soil Conservation Assistant Vinod Kumar. And third is GCE, Graduate Civil Engineer Ramesh Kumar. Their signatures are taken, everything is done. Now, my lord will see page 200. Exhibit 35.
Yes.
SP has forwarded to government examiner question documents. Kindly see, question 1 to 6 is of Ramesh, graduate engineer. 59 to 62 Ramesh. 7 to 12 Vinod Kumar, soil conservation assistant. 58 Vinod Kumar. 63 to 66 Vinod Kumar. 13 to 18 Sushant Vishwas is the Pradhan. He is the co-accused who died. 19 to 24, 50, 55 to 58, 67 to 70. All assistant director.
Correct.
What is mine? 25 to 28. Handwriting on attendance register.
25 to 28, answer good.
Handwriting by Rama Rao on the attendance register.
Correct.
Now kindly comes to page 209, exhibit 36.
Report.
Find out.
Yeah.
Now the report, kindly see point 1 to 5 first. The signatures of Ramesh Kumar, Vinod Kumar, SB Singh, Sushant Vishwas, all are matched.
2, 3, 4, 5.
All. And 6 is, so far I am concerned, there is a match. Now here I tell your lordship very honestly, I've gone through all the documents. The matching is horrible, but unfortunately my cross-examination is more on. No question has been put about the S, how this is written, how 2 is formed. The usual questions that are asked, nothing is there. Now, so I have to take the report. But now the problem is, kindly see exhibit 26. After this file, there is one book, green book.
Yes.
Page 16 to 23. Actually, it's my mistake. I should have read the LCR before I upload this.
That we always do. First we argue.
Argument aside, it was my mistake, my lord. I'm sorry, I have
Yes.
not done my duty to the book. 16 to 23. This handwriting of the names. The allegation is that I have written the names on being identified by the Pradhan. Money I did not touch. Now kindly see the stamp is there at the bottom. After page 16 to 23, in some of the pages at the bottom.
Pradhan.
So my signature, it is not even the prosecution case.
GCE, SCA,
Yes.
Pradhan
Now-
and Assistant Director.
Excellent. Now I kindly see two things. Kindly comes first of all.
SCA, what is SCA? GCE
Soil conservation assistant.
and GCA.
Graduate civil engineer.
Okay, the engineer who was
And
there.
AD is
Pradhan.
assistant director.
It is.
These are the three main people. Now kindly take up my petition for a moment, madam. The main CR.
Yes.
Kindly come to page 70. This man, Vinod Kumar, is a soil conservation assistant. Kindly see what he says. Last paragraph. Assistant Director Soil Conservation was the controlling in charge of utilization of the fund. To facilitate this program, our directorate engaged graduate engineer to ensure implementation of the program. Surveyor N. Ramarao was given the responsibility to maintain attendance register muster roll in respect of the program for the panchayat, namely Harinagar, Basantipur and Pradesham. One construction of MI pond was made at the land of Jagannath Chikta. M. Ramarao was also assigned to supervise the work and to take measurement and for making payment for the said work of the three panchayats. M. Ramarao prepared the attendance sheet and acquittance roll for payment to laborers of this work. About rupees 1,62,000 was spent from this fund for the construction of pond. I collected the said fund of rupees 1,62,000 from Assistant Director and handed over to M. Ramarao, who was directed to make payment in consultation with PRA members. Pradhan of Basantipur Panchayat was Sri Sushant Vishwas. Pradhan used to identify the workers who were engaged to do the job to collect and receive payment in respect of their work. Pradhan also used to sign in the acquittance roll. About 3770 was not paid to one worker, namely Kiran Mistry, out of that fund in regard of his work, as he expired prior to receiving his wages. This money was then deposited in government account by Chalan. So 409 goes. And so far I am concerned, I am working subordinate to these three. They are the ones who are doing the work, signing, verifying everything. My job, according to him, is to disperse payments. I will not find any document or signature for that. And now the admitted position I told.
No, but with regard to the maintaining of the register and acquaintance roll, what will?
No, that's my point. Acquittance roll, it is being signed by the assistant director. It is being signed by the soil conservation assistant. It is being signed by DC. Whatever I am writing is on the identification of the panchayat pradhan. I am not a local person admitting. I am going from Port Blair over there. They are saying these are the 10 people who will work. This is their name. I am writing down them. That's it. Now, my lord, can you see page 73? Cross examination. Page 73. This is very wide. I was posted at Mahabandha since the year 2004. RGRP was launched in the year 2005-6 and M. Ramarao was assigned to look after the respective job in regard of this program on the strength of office order. Graduate civil engineer was assisting M. Ramarao in the job. I also used to supervise the job. With the concurrence of Panchayat Pradhan, PRI representative, no payment could have been made to the laborers. M. Ramarao, myself and civil engineer were not local public of that area. M. Ramarao was authorized to maintain master roll attendance record in regard of the work at the said three panchayats. Pradhan and PRI furnished the list of workers who could be engaged to perform the said work. And the next line is more vital. The job was completed as per specification. So it's no one's case, work was not done and money was misappropriated. Work was done, then who did the work? Because those who did came and signed and took the money.
So who has made a complaint?
The complaint is made by the son of Hiren Mistry. But he says, Hiren Mistry is dead and gone. My father's money has been given to someone else. What happened actually, my lord? He came and he demanded that money for his father. Now, why I showed the dates? Because he was admitted much later. He was not dead when the work was done. So the point is, the father worked. True. The son came to take the money. We said we will not give in your hand. Which may be right, wrong, whatever. The father was in hospital. But the son says, you didn't give me, you made fake signature and you gave it to someone else. Which is not the case because the money went back to the treasury. So that allegation goes. The second allegation, which is a counter allegation which the prosecution has made counter of its own case, that other witnesses, some are saying, we never worked, we never took money, we don't know whose signature this is. The point here is, the money as far as the work being done, there is no doubt because
Work is completed. Work is completed. It
and
is not
who
the.
has supervised? These three persons. Now,
But they are not the accused persons. They are
now,
not the
why
accused.
you took the special signature and why you said. And now, if we go by the report against me, then the same report has to be used against them.
Correct. That's
But-
totally.
But pick and choose, they were made into star witnesses. No matter what I see. Now see page 74, madam. More. The official record document of acquittance roll was prepared by office staff, not by me. What he said in chief now has changed. No outsider put any endorsement there. Volunteer. Party concerned signed therein after receiving payment. And Pradhan Sushanto Mishra signed therein, proving as witness to the fact of making payment to the party concerned. Then at the bottom, I did not visit at the spot at the time of payment. Then how you could sign it? During construction time, I visited occasionally to supervise the progress of construction. I saw some PRI member at the spot of construction when I went there. Whenever I went at the spot, no villager or laborer made any complaint to me regarding payment and construction. Now, this is the first man, Vinod Kumar, who is a soil conservation assistant. Now, my lord will see page 77. This is the second gentleman, PW3, S.B. Singh.
Assistant
He was
Director.
The assistant director. I am posted Nankori
Ramarao, sir.
Ramesh Kumar, junior engineer. M. Ramarao surveyor were assigned to monitor the progress of work, taking attendance of the laborer worker, preparing muster roll, and to make payment to the party concerned, which they collected from Vinod Kumar. About rupees 1 lakh, something accurately I cannot recall, was handed over. Ramesh Kumar, M. Ramarao prepared the master roll of this job for making payment to the workers. So Ramesh Kumar, he is implicating actually the graduate civil engineer. But Ramesh Kumar is examined as PW7 letter. except one worker who died before receiving payment, the remaining entire amount had been disbursed to the workers being identified by Pradhan and Panchayat member and one respectable person of the village. What prosecution case goes? Pradhan, whose name I cannot remember, endorsed his presence by putting signature in the master roll. Pradhan and Ramarao are in the courtroom. The undisbursed account is of in regard of the wages of that worker who did not receive the money was deposited in the government account backed by Chala. Last page, last line, Pradhan signed and made the certification in the master roll to the effect that payment has been made in his presence. This is the said signature and certificate, mark pencil so-and-so. This is the signature and endorsement of Pradhan in the other acquittance roll, mark so-and-so. Then my lord will see page 81, cross.
Yes.
I visited the spot on some occasions to see the progress of the work. Payment to the workers were made in presence of Ramesh Kumar, Ramarao, Panchayat Pradhan, member of Panchayat, and respectable person of the locality. I put my counter signature after verification of payment made to the workers. It is a fact that except one worker who died, all other workers who worked got their payments duly. It is a fact, after two lines, it is a fact that party concerned, workers and Pradhan signed in blue ink in the acquittance roll. Then he clarifies, I was not present at the spot during payment to worker. And why? Because his signature and stamp is there. If he says he is making self-implication, then it is a fact that Pradhan did not write anything in his own handwriting in the acquittance roll. It is fact neither PRI member nor any responsible aged person of the locality signed in the acquittance roll. So responsibility is yours. Now kindly comes to page 90. This is the third gentleman, PW7, Ramesh Kumar.
Yeah.
4 lines from the bottom. In the year 2007, the work was assigned to one Ramarao who was a surveyor. So far as the payment of laborers was concerned, the payment had to be made by the surveyor Ramarao in presence of local Gram Panchayat, who was to identify the laborers. And even myself and one Vinod, who was a soil conservation assistant, was asked to be present for payment. So now he's implicated PW2. The signature of the Pradhan used to be taken in the acquittance roll, and thereafter the same is to be submitted with the office of AD Agriculture. Rupees so-and-so was eventually paid to Ramarao, who paid his laborers accordingly. Then next page, cross my lord will see page 92. About 10 lines on the top. This is a said estimate report prepared and signed by us. Let the report be marked as Exhibit A. I cannot say whether any payment was made in respect of the work done in the year 2006 prior to stoppage of rain. This is very vital. What happened, my lord knows when work has started, rain starts, work stops. That's why I showed that acquittance roll of 2006.
July.
Work had done earlier, then rain came, it was stopped. Then work started January, February when the rain stopped. Now this man is saying, under the middle, it is fact that myself and accused Ramarao resided at Mayabandar at that time. It is fact that at the relevant time, myself and Ramarao used to go from Mayabandar to Procedural to supervise the work. It is a fact that myself and Ramarao did not know any of the laborers who were used to receive the payment. They used to be identified by the Pradhan.
Again, yeah.
Again, the acquittance roll is shown to the witness. It is stated so far as payment of Indian ministry is concerned, no payment was made to it, neither his signature or LPI appears. Then on the next page, it is I cannot name the persons or authorities in whose presence the payment was made. It is fact that in the acquittance roll, the signature of Pradhan and AD Agriculture Mayabandar are evident. Exhibit 5 is shown to the witness and he states that the words payment of persons mentioned at serial number 1 to 40 has been paid before me, except serial number 22, and thereafter the Pradhan and the signature is identifying that as well. Now, if I am to look at these three were meant to be the principal in my very humble understanding. Now, after the report of GEQT, which matched their signatures, they had to answer how they supervised, how the payment was made, how the work was done. Instead, they were made the star witnesses, and this man becomes a scapegoat who actually does not have the authority to sign on any paper or do anything except what he is ordered to. And in this background, your lordship will consider two things. Now, thereafter, the witnesses are there, they are saying we didn't work or the work was not done. admittedly, the work had been completed. Now, in this case, if the work had not been done, some false report, then 468, 471 all would have come. That didn't come because the work was there.
No, even if it is come, then this accused, the other person
The
has to
other
be in
person
time.
has to come.
Other person has to be in time.
Now, at best, I can say what would be the prosecution case? Because these witnesses, now you have chosen them to be your star witness. Therefore, you have to now abide by it. You can't say they were also involved. When you are abiding by it, you have to accept that Shushanto Biswas, the Pradhan, used to know the persons and I never knew the persons. So who is giving
Identify
consent?
them.
I'm writing. Now, in light of this, my lord, I'm beseeching your lordship to look only at one more page. Kindly come to the FIR at page 35.
Yes.
Now, three things I will show. First of all, can you see the date of the FIR? 30th August 2027. 27,
29th August 2007.
2007. No, no, 30th August.
Which one?
FIR, right at the top. Page 35 of my petition.
Actually, petition. Yes,
So the date of the FIR at page 35 is 30th August 2007.
correct.
Now kindly see it's the last line. Details of the known suspected accused, agriculture departmental employees along with the existing product. So I was not named as a person who is responsible.
You're not a FIR named person.
Never. But when it's a departmental employee, Melody did cover the entire picture. Now, when your lordship sees the charge sheet, page 41. The first person named is Rama Rao at page 42. And my lord will get at the relevant portion, page 52, 51 and 52. 51 last paragraph.
Yes.
It is naming Rama Rao, Shushanto Biswas. All the other persons are banished. And instead, their names are appearing at page 45, serial number 2, 4, and 8 as the witnesses of the case. Now, this case has been going on since August 2007. 18 years this man has suffered. Now, in this background, my lord, with the greatest of respect, may I submit that the law has been clarified so far as this.
Come after lunch.
Study my London submitted a page for remanding back on the ground of background and the statement and the section 3. If we will go into the merit of this case regarding that part, one day.
I will hear no problem, sir. No problem with regard to the opportunity of hearing from this court.
Regarding remanding back,
Sure.
I will not.
Sure.
I'll give.
No problem. If the court is going hearing on merit, then naturally you will get an opportunity.
then I would just show you also another three things. Kind of takes the NCR for a moment.
Yeah.
NCR.
Yes.
When I would see page 59, exhibit 19. These are the final nails in the coffin of the prosecution.
Page.
They are writing page 59, exhibit 19. There is witness writing to the SSP.
Give some breathing to Mr. Karmagar. If you take all these things, how he will breathe.
Before starting, my part can be taken.
No problem. I told you. The whole night you go and read.
I am ready to see some.
Come, no problem. No problem. Yes, 59.
59, exhibit 19. Yes, that same assistant director, he is writing to the SHO on 7th of September 2007. Kindly see point number 3. What work I was assigned? Only for attendance themselves.
I was assigned the duty of preparing attendance register for the division engaged.
That's all.
And as per the evidence, the attendance register, the persons have been identified by the Pradhan and the PRI.
Second is point number 4. Kindly see who has made the bill. Page 59 and 60.
SCA.
So that is Vinod Kumar.
Yes.
And point number 6, money was actually handed over to Vinod Kumar. Vinod Kumar is saying money was handed to me. Can we see who the money was actually handed?
That evidence gone.
Gone. Then madam will see page 80, exhibit 8. This is my deputation order to do this work. Kindly see what is my role. Only to assist the soil conservation assistant.
Assist this organization in excavation of the
That's all.
money.
So I'm directly under the PWD. And then madam sees page 95, exhibit 28.
Yeah.
Again, assistant director writes to SHO, 14th of November 2008. First point, no specific order or receipt is there with regard to me. So my involvement comes down to 0. Job is of the soil conservation assistant and graduate engineer. So PW2, PW7. And identification has to be done by the Pradhan. And then finally, point number 3 shows that the work was carried out and completed. Another I am only troubling your lordship for a moment longer. The law laid down in 2008. That's the Now, from paragraph 5 onwards, the discussion is there about 330. They have discussed all the judgments. I'm not wasting your lordship's time. But I'm only pointing out 2 portions. Paragraph 13 first, my lord, kindly see.
Yes.
This is obvious established position that there's a duty to put in the inquiry or the questions to explain any other circumstances. Anything he realized he has to put. My lord knows, has seen, it has not been done. Thereafter, 14 is relying on Bobade. 15 is discussing again the object of examination. 17 is specific. Now 18 and 19 I wanted to point. 18. In certain cases, when there is perfunctory examination under section 313 of the code, the matter is remanded to the trial court with the direction to retry from the stage at which the prosecution was closed. Then 19. In the extent case, the questions put to the accused in the examination under 313 read as follows, it is there. Then 20. As rightly contended by learned counsel for the appellant, no witness has stated that on the date of occurrence, the accused had got severe injury to the deceased by assaulting him on the head from behind. The circumstances which were relied upon by the trial court to find the accused guilty were not specifically brought to the notice of the accused. Therefore, in essence, his examination under 313 of the code was rendered an empty format. On that count alone, the impute judgment cannot be sustained, set aside. Conviction recorded stands set aside. So the point is, it may be remanded back. But if the evidence itself is not there, then remand back serves no purpose. And this has been reiterated in 2009, very specific observations. This is Shamsul Haq, quoted in 2019. I have noted the paragraphs, but not I would specifically beseech your lordship to come to paragraph 23.
Gopde.
This is Shamsul Haq relying on both. But the observation here is very interesting. While making the apostle observation, this court also referred to its earlier judgment in Bob, which considered the fallout of the omission to put to the accused a question on a vital circumstance appearing against him in constitutional evidence, and the requirement that the accused attention to be drawn to every inculpatory material so as to enable him to explain. Ordinarily, in such a situation, such material as not put to the accused must be eschewed. No doubt, it is recognized that where there is a perfunctory examination under section 313 of the court, the matter is capable of being remitted to the trial court with the direction to retry from the stage at which the prosecution was closed. We are, however, not inclined to follow that course in the given circumstances of the case, that the inconsistencies in the testimony also creates doubt in the case of the prosecution for any role of the accused number. Thereafter, there is a discussion of the entire thing. Paragraph 25, we are thus of the view that the prosecution has not been able to establish a case against accused number 9, much less reasonable doubt. Thereafter, the other accused who were in custody, their evidence against them was considered. And after considering, my lord will come straight away, paragraph 33. After discussion of the evidence aspects. The subsequent testimonies, however, sought to assign a different role than the one assigned in the FIR, bringing about inconsistency. The view taken by the trial court is at the least a plausible view, though that may not be the only plausible view, or if one may say even the less probable. We are thus of the considered opinion that the prosecution has not been able to prove the case against reasonable doubt against these accused, and they must get the benefit. The result of the aforesaid finding is that Shamsul Haq is entitled to clean acquittal, the others are entitled to acquittal record. So my point here, one, I have argued 313 is there. So in the worst case scenario, it has to be remanded. But if the situation, this is case of 2007, my lord. 18 years have passed. In trial, appeal, now coming. Now, if we are to go back and restart, madam, the proceeding of the penalty of the proceeding is worse than the penalty of conviction of the accused. And in this light of the matter, I beseech this court, the lordship knows this is the revision. So, 482 is in pivotal scope to where there is perversity. Now, I have shown the perversity from the evidence. The documentary evidence does not get the support of the witnesses. The witnesses try to tell a different story so they can save their own skin. In this light of inconsistency, Supreme Court is saying we will not take the course of remand. So this is this. Thank you.
Tomorrow,
I will conclude.
at the Learned Council for the petition, concluded. At the Learned Council for the petition, public prosecutor press for time according to the law. Let the matter appear tomorrow as a specially fixed matter.
I'm not pending that.
What it is? This one.
Because conviction was there.
Interim order is extended. Yes, next. Yes, so it's for the prisoner. Yes, why you are not appearing? Why you are not appearing with the Okay. What is the case about?
I'm not thinking about the file.
Okay.
Matter, I have applied the election.
Who is for the other side? Sir is there. Yes.
Matter, I have included contact revenue land. And then I have applied, kindly come to the number, where my application.
When you applied for?
I applied on.
What they say in the affidavit in opposition?
They have filed up into, but I have to file the reply. But before that, my lord, I have been sufficient that I will settle position in the government level. Various judgments are done, my lord, in favor of the petition. My lord,
Yes.
and my lord, in fact, my lord has passed the several orders in favor of the petition, those who are in the
settled position. I am very much, I am not understood that why they are filing the opposition, affidavit opposition. Even if I am in the settled position and it's a government, they are suggesting and they are telling us that go and ask the NOC from Tahsildar. Is it possible, my lord? And the enclosure of the particular land, whether the concerned Tahsildar will give the NOC, it is not possible because I am the enclosure, my lord. So my humble submission, my lord, my electric wire is going through my roof, my lord. I am suffering from last several years, my lord. My children are suffering, my lord. And this is the school going from examination time, my lord. And they are saying that this is constructed by wooden bamboo house. I am the poor man, my lord. How can I construct a papa house? I am constructing my own capacity to build a construct and dwelling house. My lord, I am today and humble submission, my lord. Kindly provide these poor people is very deprived, my lord. Kindly.
Where is the other side? Mr. Mishra?
Lordship, I'm not bearing, Lordship.
Yes.
Lordship, kindly come to page number 5 of the writ petition.
Page 5.
Lordship.
That is the ground. Page 5 is the ground, sir.
Paragraph 5, Lordship. I am sorry. Paragraph 5. It is a RCC house. And kindly go through the photographs, Lordship. Nothing more I will submit.
But this is not the subject matter. Maybe they have constructed RCC buildings. Well, they have
And
outlined.
the affidavit they have said.
Mr. Means, you have filed this writ application by affirming an affidavit before the oath commissioner. And kindly come to your verification in the affidavit portion. Come to the affidavit portion. Page 7. The statement made in paragraph 1 to 12 and the paragraph 13. With respectful submission, and I have concealed nothing. Where from you got this type of the affidavit? And the above paragraphs are true to my knowledge, being derived from records.
This may be this paragraph 5.
Where from you got this format of affidavit?
I not for paragraph 5. I'm totally disagree.
So?
Maybe it is typing still my lord RCC building. But my lord, they have
This type of writ petition should be dismissed with cost. At least sometime I can get a cost.
And what if my lord? If I will in the settled position, I have constructed a house.
But you have
That
given.
for that my lord, paragraph 5. Maybe it is a typing mistake because earlier I have typed even maybe a copy. This much I can submit on my side. Because
It is
earlier.
not typographical error, Lordship. In all his petition, that paragraph number 5, it is the same.
You file supplementary by correcting this.
My lord.
By tomorrow.
My lord, my lord.
Day after tomorrow, the matter will come.
My lord. My lord.
Mr. Min, learned advocate appearing for the petitioner, has argued at length. Well, counsel for the Mr. Satish Mishra, learned advocate appearing for the administration, has pointed out the statement made in paragraph 5, which reads as follows. So, Kardina. Mr. Mishra also draw the attention of this court. The photographs appearing at page 15, which shows otherwise than the paragraph 15 of 5 of the writ application. Counsel for the petitioner prays for leave to file supplementary affidavit by correcting the statement made in paragraph 5. Leave is granted. Let the supplementary affidavit filed tomorrow. Leave the matter day after tomorrow.
Lordship, how he will file tomorrow because his client is residing at Diglipur. Lordship.
Yes, next.
I am appearing for the respondent. Lordship.
Yes.
There was a direction to file the supplementary affidavit. I have received in WhatsApp the supplementary affidavit.
What is the supplementary affidavit? Report. What report you?
Lordship, a encroacher already having a electricity connection. Once again, they are saying that there is a family dispute. So they need another one connection. It is for livelihood, not for livelihood. This is the tendency of the petitioners.
Yes, let the petitioners.
Lordship.
No, my lord, the report has been furnished by the other side stating that the electricity connection is in the name of Sunil Sarkar, who is the father-in-law of the petitioner. But my assumption is that, yes, I accept this, that father-in-law Sunil Sarkar, name electricity connection is there, is the reminder where is the father-in-law and their children are residing. But the premises upon which I am claiming the electricity connection is the enclosure I have annexed in my supplementary affidavit and the
Where is the report? Report time. Administration.
Lordship, I have already handed over to this honorable court on the last occasion.
report is different. What the house is different. But in the survey of the house, if the photograph is annexed by the along with the report by the other side. And the photograph which I have annexed may be seen in my supplementary. It is semi-artificial, the floor and some part, means 4 column of that hollow block is RCC and above that is of the and also wooden. This is another structure. And this lady is not residing along with her husband due to some dispute. Here what happened? After marriage, she was along with her husband. But before marriage, she has enclosed this land along with her mother. And after 2 years, and she was not that she is not in the position, or that she was in the position of the landed property, because this property is not so far away. And survey number also I will mention. But in the report which has been given by the other side, the survey number is there.
But you are having already 1 meter Z699.
My name.
Whose name? In the name of Sunil Sarkar. Your house is separate from this house, but their report is something else. Where it is? Hadbe.
Yes.
It is Hadbe. But they are
filed the affidavit saying that there is no electric connection in the encroached land. That affidavit itself is a wrong affidavit, Lordship.
No, the photograph makes the.
No, your house is different than the house of. There are 2 houses. Hey, report. Where is your report, Mr. Mishra? This is not.
I have already submitted before the court.
By a letter.
Lordship, by a letter.
Letter dated 6th May, 11 June.
10 June.
Lordship, 10th June.
There.
I have already supplied the copy before the honorable court.
So they are telling that along with the understanding was found the semi-dwelling house for which the encroachment connection was sought Srimati. Now the same dwelling house already in existing and active position. Okay, I am do one thing. You bear the cost. I am appointing a special officer.
Lordship. That will be better.
Cost amount. Because she.
Advocate has to go to the headway.
My God, she is not.
Lordship, I may be sent to admit. I have never been there.
You have to retain the panel, then I will appoint you.
Lordship, that may be recorded that your advocate also will go. Departmental advocate. I can get the opportunity to go there in Little Andaman.
They have said. And mine is in my supplementary.
Okay, let report come. Let the report come. Who?
Right.
So what can be? Has to
Low
go.
cost.
Lordship, when circuit is not there, I may be get an opportunity to go Little Andaman. So my name may be also recorded that departmental advocate also will go.
Is that the authority have filed a report dated 10th June 2025 is stating that the semi-RCC dwelling house for which the encroachment connection is sought for by the petitioner, comma, the same dwelling house is already having the existing meter connection number A/C number Z, capital Z 6/1999, provided on 19th May 1992 in the name of Sunil Sarkar, within bracket father-in-law of the petitioner. Full stop. The counsel for the petitioner disputes the report submitted by the authority, that is the Assistant Engineer, Electricity Department, Hadway, and submitted that the petitioner has constructed a separate house and is residing in a separate house in which no electric connection is provided. Considering the report and submission made by the counsel for the petitioner, this court find that to resolve the issue, resolve the dispute between the parties, whether the petitioner intend to obtain the electric connection in a separate house or the petitioner is intending to obtain electric connection in the same house where in the already an electric connection is provided. A commissioner, an advocate commissioner is to be appointed to see, number one, whether the house of the petitioner and the house of Sunil Sarkar, wherein the electric connection being account number Z6/99 is provided, a separate house. Number next, whether the house of the petitioner is separate than the house of the Sunil Sarkar. Who will go? Hadway? Oh, junior, I will. Who will go? The junior?
Satish Chandra Misra.
Huh?
Satish Chandra Misra.
I don't know. You go. Mr. Adarsh Silango.
Lordship, I object to it because they are from the same.
That's why.
I object to it. Somebody else, not from chamber of Mrs. Nag.
You tell the name. I don't know. So many new faces are here. Who is interested to participate?
Pardesiya Munda. Pardesiya Munda.
He's the same chamber.
He was also same chamber.
You? What is your name? Can you go? Hadway. So, so is appointed as commissioner, and is directed to submit the report before the next circuit bench. Can you submit the report by Monday? Can you go by this week?
Lordship, not Monday, Lordship. I may get a chance to go ahead because of your Lordship. So next circuit bench?
By 14th July 2025.
Lordship, 14 this circuit bench. Next circuit bench, Lordship. I will also go.
The duration of the commissioner is fixed rupees 10,000.
10,000 is very less, Lordship. Lordship, that may be recorded that advocate of government department will also be present there.
Because at the time of inspection, the commissioner shall issue notice to both the parties.
Lordship, that may be recorded, Lordship. Please, Lordship.
Yes, next call.
Obliged, Lordship.
Yes. Yes, you got the rule. What the respondent will do with the law point? Yes, which rule? Procedure of follow the tribunal. Application for payment of compensation made under section 166. Right?
Last item, also same.
Last item.
Last one.
Okay. Summary dismissal of the application. Party summoning, interference, inspection of the vehicle, method of recording, adjournment hearing. Premier is the determination, diary, judgment and award.
My lord, that is clearly covered under section 176.
Yes.
And my lord, pursuant to that, my lord, we found out that the Andaman and Nicobar administration has in fact issued a regulation. And under that regulation, my lord, a fixed court fees is prescribed. So in that view of the matter, my lord, in terms of what had fallen from my lord, this order is perhaps erroneous, my lord, because it is contrary to the regulation which specifies a fixed court fees. Mr. Rakesh Kumar, may please hand over the
Order 5, Order 9, Order 13, Order 26, Rule 2, Order 40, 17, Order 23, Rule 1 and 2.
116, in terms of 176, the purpose to be given under the Motor Vehicle Act to form a rules.
176.
Yes, 170 the Motor Vehicles Act.
Yes.
It will not say 116. Every application for payment of compensation made under section 166 shall be made in the form of CTA and shall be accompanied by a fee of ₹21.
So, my lord, fixed court fees is already prescribed. So, in that view of the matter, my lord, it has to be fixed court fees. It can't be done ad valorem.
No payment of court
It
fee.
is here after that the procedure has been given, what is elaborated under the act.
And how you can say these are under 176?
So it is a first page, what it is given.
It says so at the very beginning.
Read with 41.
41, 36.
Left and one. Yes. Yes.
Here is that. And not. There will be application of order 7 for rejection of. This is not a money to add an application, so as prescribed under the rules, the petitioner has already paid the required court fee of ₹20 during the filing of the application. This was not been acknowledged in the order.
₹1 is to be paid. 20 only or 21? 20.
But these rules are not brought to the knowledge of the honorable district.
Yes.
Because in Calcutta, they have been imposing the court fee based on the quantum compensation.
It's a rule. State is even the every rules and provided the quantum what court fee is to be as our court fee. Yes, anything? Item number 20.
Same,
Other 7 rule 11.
yes, sir. Same.
Here also.
There are the petitioner and the.
Order has to be self-cited.
Both them. This appeal is against the order passed by the learned, the sole member of the Motor Accident Claims Tribunal from Andaman and Nicobar Islands, Port Blair, in MSCT number 4 of 2024 by order number 148 dated 20 February 2025, wherein the sole member of the tribunal rejected the claim application filed by the petitioner claimant under Order 7, Rule 11 within bracket C of the Code of Civil Procedure from 1908 for non-payment of proper court fee, public stamp duty. It is fine from the impugn order. The learned judge and the learned sole member of the learned tribunal was of the view that has assessed the court fee of rupees 7,237, out of which the claimant slash appellant hearing had paid only rupees 20. And as said, the learned sole member has learned tribunal has dismissed, rejected the claim petition as the appellant slash claimant has not paid the required court fee. The petitioner has preferred this present appeal on the ground that the learned tribunal failed to appreciate that in the Andaman and Nicobar Island there is no need to pay any court fee other than rupees 20, and rupees 20 has also already been paid by the claimant at the time of filing of the claimant. Full stop. Learned advocate appearing for the state. No, this court has taken the assistance of the learned senior advocate, Mr. Chakravarti, appearing on behalf of the state along with Mr. Rakesh Kumar, to ascertain whether the Andaman and Nicobar administration has framed any rules with regard to payment of court fee / stamp duty on the amount awarded by the tribunal in the motor accident claims cases. Full stop. Mr. Chakravarti has provided the copy of the notification dated 18th April 2006, issued under Section 176 of the Motor Vehicle Act, read with subsection 41 of Section 2 of the Motor Vehicles Act 1988, wherein Chapter 11 refers to the claims tribunal, which reads as follows. यहाँ से लेकर के यहाँ तक का setup. This court has perused the rules 116 and 117. Rule 116 is regard to the application for claim. In the said rule, it is provided that every application for payment of compensation be made under Section 166 shall be made in the form. What is CTA? Form -CTA, and shall be accompanied by fee of rupees 20 only. That Rule 117 provides for procedure to be followed by the tribunal. In the present appeal only with regard, only the point is to be decided whether the claimant is required to be paid the court fee as assessed by the learned tribunal. On perusing the rule framed by the administration, being Rule 116, this court finds that the application of the claim has to accompanied by only rupees 20 only. There's no further provision for payment of any court fee or stamp duty on the awarded amount. This court also finds that under Rule 118, the power vested in the civil court which may be exercised by the tribunal is Order 5, Rule 9 to 13 and 15 to 39, Order 9, Order 23, Rule 3 to 10, Order 16, Rule 2 to 21, Order 17 and Order 23, Rule 1 to 3. In the rules framed by the administration under Section 176 of the MB Act, it reveals that Order 7, Rule 11 is of the CTC is also not applicable in case of in the application filed under section, filed for grant of compensation under the motor vehicle. Considering the above, this could find that though the Andaman and Nicobar administration has framed the rule under section 176 of the Motor Vehicle Act, and a separate chapter has been given with regard to the claims tribunal, but the administration has not provided any provision for payment of any stamp duty or court fee on the awarded amount. This court also find that Order 7 Rule 11 of the CPC is also not applicable. And as such, the interim order passed by the London Tribunal, this being order number 148 dated 20th February 2025, wherein the London Tribunal has rejected the claim petition under Order 7 Rule 11 of the CPC, is perverse and required to be set aside and accordingly set aside.
Most grateful.
You do
My lords,
want, you give this copy. It's a copy from Patna. Same order.
My lord, my apologies for appearing virtually because of some personal reasons. I had to come to Kolkata day after I'll be there.
उसमें ना कभी देखना पड़ेगा, पर देखना है। चलें, चलें। Next. This ले गया। ये my list.
The partition to the civil judge civil division on there being admission by the defendant in share.
Yes.
This was issued
Yes.
on the ground that my client at the time of what that's is participated. That's the only. For the properties in the name of.
Why you had appeared in the Bhumi Puja?
That's the very my client. I mean, it's not open non-application. But I just don't know the.
Yes, let me hear. Yes, Mr. Bhumi.
Let me also to details of the special study. Let me make maintainable to the government.
Why?
Because in judgment, so my lord.
From the Andaman plantation.
Every not judgment.
Huh?
Number 40. Talking parts.
Page number
40.
40.
40. Our book.
Hmm.
The operating court is at my lord, page number 45.
Yes. Regulation 11, 1940 or subsequent application on the first appeal cannot be held by the High Court. Further section the district judge where the value of the order suit rising decree did not exceed 1,50,000. Then what is that?
I've suspected bidding more than 1.
But not exceeding 1,50,000. It is before that. It is more than exceed 150. High Court.
I did. But my lord, the Chinese is the order of the division. Which is charge that is very fully.
Correct.
And even the before my lord in this circuit, that was also civil. For my lord, pardon, the previous.
Correct. Appeal is admitted subject to outcome. I don't think so.
A single day. Yes, before the division. My lord, how is then?
No, because the if it is a first appeal, it will go to the single bench. It can go to the second bench and the second.
And the very first, remember, there are two grounds before it's all open to can happen. One is that I'm undertaking construction. Second is of the operation of the. My lord, the other side first on the first part that construction is going on, they just request my lord to kindly speak photographs and expose at page number 7. Building was completed in the year 2023, a day of housewarming. Status quo was granted by the honorable shore. By virtue of that, not flexible. After all parties, they say that the construction is going on, at my call, when the council.
You are in occupation. Correct. No, you are not making any
No, I'm not making any loss.
correct. Let the appeal be admitted and status quo be maintained. You are in occupation. What for?
One flat is there, one we are still ready to keep the flat. All the flats are constructed in the same,
I am not deciding the
so
issue.
my humble submission is that they are claiming 1/6 share. We are ready to give 1/4 share. The other has constructed 4 flats. She relinquished her.
So I am sending you the mediation.
No, I'm ready for that. No, I'm ready for that.
Say, no. Hills are still no protection. What? No.
Yeah, he is telling that he is not
I'm
making
not
any.
giving charity. They are.
It's not.
Mr. Jaipal, now he's telling that he's not going to make any construction and he's in occupation. Admitted.
Clearly, it's not occupation.
Let status quo.
Yes,
Status quo as on date and status quo as on date.
We have entered and we have decided in 3 of the flats.
Possession.
Why not? Judgment was passed by the court, they was vacated.
Application. I participate within Puja. Total one application.
The appellant has preferred the present appeal against the judgment and decree passed by the learned. Where is the appeal?
So not 5 to 47 in the CR.
Against the judgment and decree passed by the learned Civil Justice Division at Port Blair in title suit number 35 of 2023, dated 2nd July 2025. The counsel for the respondent submit that the appeal is not maintainable as the point with regard to jurisdiction of this court, whether this court can hear the appeal is pending before the Honorable Supreme Court. Honorable Supreme Court. Concerning the submission made by the counsel for the respective parties, the appeal is admitted subject to the result of the special leave application pending before the Honorable. The appellant has also filed an application being Can 1 of 2025, praying for interim, praying for stay of the operation of the judgment and decree passed by the London. The main contention of the appellant that the respondent has started after the judgment passed by the London Civil Justice Division, the appellant has started construction over the building, and there is every chance that they will alienate the property in favor of third party. Mr. Rakesh Govind, an advocate appearing for the respondent, submit that has filed the affidavit in opposition and draw the attention of this court to the photographs enclosed in the affidavit in opposition from page 47 to 53 and submit that construction has already been completed and the appellant is in occupation of the premises and the respondent has already completed the construction and in occupation of the premises. And he submits that one flat is already lying vacant, being the share of the appeal. Considering the submission made by the counsel for the respective parties, full stop. The learned Mr. K.B. Jaipal, an advocate appearing for the appellant, submitted during the pendency of the suit there was an order of status quo, and the same was continued till the disposal of the suit. In view of the above, the parties are directed to maintain status quo with regard to nature, character, and possession of the property till the disposal of the. Status quo over the property as on date till the disposal of it. Can number 77 disposal. The appellant is directed to prepare a requisite number of paper book within 4 weeks and to serve the copy to the learned counsel for the respondent. Full stop. The trial court record may be called for within the conference. ये ऊपर आए तो नीचे the matter will be listed on upon mentioning by any of the parties after notice to the parties. Server copy you will get. Server copy. Okay, take a back copy there. Yes, next. Yes.
All the legal. Now.
To whom you are appearing?
Only that
Venkatesh?
Page number 3.
So they are not engaged any lawyer. Notice served.
I have said it.
Not received.
So I will take steps for.
You are appearing for only? Yeah, respond number?
What? It's not responding to what?
Legal.
Not responding.
It is a legal layer.
Legally.
Venkateshwar.
So you filed an application of substitution.
Yes.
Can number?
Can two is for section 5. One for substitution.
One. Mr. Vijay Kumar and advocate appearing for the one of the legal layer, namely Venkateshwar. K. Venkateshwaralu. K. Venkateshwar. And he submitted he has no instructions to appear for other legal layers of the dependent. Dependent. So counsel for the appellant submitted, she will take appropriate step for issuance of notice upon the other legal layers of the. In view of the above, the case is left on and the matter appear before the next applicable circuit bench. In the meantime, the appellant director take appropriate step for service of notice upon the other legal layers of the dependent and to file affidavit service on the next date fix. Next.
And for the respondent matter.
Yes. And cause the order of impugn must have any appeal.
Issue has already been decided by. Upon recording my entitlement, the deputy commissioner was directed to take a decision in that line. I'll show that.
So Japan appeared in the matter, I think.
Yes. One. Yes, sir. I'm sorry.
Released simple. No? Released.
Right.
Yes. Next, not today.
25, my lord, I am seeking extension of time to file opposition on behalf of the added respondent.
Who is the added respondent?
Ministry of Port and Shipping.
He also filed a CAN application, madam, for seeking permission to park. He filed it, but let him file the reply to the extent because.
What application you filed?
But for seeking of the court.
Permission of the court to fly the vessel.
Charges, my lord, because.
Average.
To pass the final order, dictated by this honorable court after
This court has, that they will participate in the Stockholm proceeding, but the final order will not be passed without the leave of it. You file the tax, it is seeking.
Sir.
I am waiting for the final order.
Yes, Mr. Balan. What do you want?
I am seeking extension of time to file reply.
Yes.
Opposition.
See, you have brought time.
So the court has said that, there is a power of authority to.
No, they have only, right.
So they, without hearing them, they cannot.
Mr. Sivabalan, an advocate appearing for the added respondent, praised for extension of time to file affidavit in opposition. Let affidavit in opposition filed by 2 weeks. By 2 weeks. Reply if any there to be filed within a week thereafter. Can I record no extension? Let the matter appear before the next available circuit bench. Next. Let's see, start. Somebody junior take note of it. 15 minutes, 20 minutes are there. Yes. If you want the next circuit, I can give the next circuit. If you want next.
Because since beginning, every circuit they're asking for. No, I'm telling about you. I'm telling about the other side. They didn't work on that way.
2024, man. Those. Then advocate appearing for the respondent is for 60 matter before the next circuit bench. Accordingly, as per the prayer of the respondent, it is adjourned. Let the matter appear before the next circuit bench on the very first day at the specifics. What is the matter, Mr. Jayapal?
My property was given to the private respondent. My father was enjoying property. On a fine day, I could see the record that it's their private. It's the.
You are for the private respondent. So you not file the affidavit. Who sold? Petitioner.
My lord, during my lord's 2023, see, my lord have other input. At page 71. The 49.
Then you pass an order. Page 75.
Same order.
Same one.
On the, my lord, same one. Same reasoning, same thing. There's no possibility of change in the issue law. Same. My lord, it's same. Page 62.
Also, we will find. So, what can be done? Yes, Mr. Jayapal, it's time. The respondent number 4 and 5 praise for extension of time to file affidavit in opposition. Let affidavit in opposition be filed by 2 weeks. Reply if any there to be filed within a week thereafter. List the matter before the next available.